It's a big decision for a client, whether to go to court or to settle.
We are very aggressive at negotiating out-of-court settlements prior to even filing suit. Some cases you got to file suit on. Most cases you shouldn't have to if you aggressively negotiate that case.
95% of our cases get resolved without going to litigation, and that's because the negotiators have to negotiate every case twice a month.
Since we are such a large firm and have such a large client base, we don't have to take the first offer, the third offer, the fifth offer, the 10th offer.
We wear the insurance company down.
Insurance adjusters either settle for the right amount or become frustrated that Cusick won't take the offer.
Why don't you guys take it? What's wrong with you guys? It's like, well, it's not fair. It's not what reasonably could be anticipated if we took this case to trial. And until you get us that number, this case is not settled.
When we look at a case, the goal is to work up that case as if it is going to trial. That's how you get a case settled, is by working it, taking it to the hilt, so to speak, like you're going to trial. And that's when the insurance company realizes, okay, these guys are serious.
Once we get the settlement figure that we think is as good as it's ever going to get for the client, and we haven't had to file the lawsuit yet, then we would present it to them. They would know to the penny who gets what goes where.
But sometimes the client feels the settlement offer is not enough.
The decision on whether or not to litigate is fairly complex. There are a number of factors that would come into play in making that decision.
We evaluate, will the cost of taking it through litigation exceed what the value of the case is?
It wouldn't make sense to anybody for us to spend $20,000 in additional litigation costs in order to get the client another 10 grand. I mean, maybe we'll make some more money, maybe an expert will make some more money, but if that means the client's net share shrinks, we're going to recommend against it. You know, we want to deliver to the client's bottom dollar net share the best possible outcome, and that's usually when that decision to whether to litigate or not would come into play.
It's always the client's decision. So I don't try to persuade the client one way or the other. I'll give my opinion. We'll lay out the facts. We tell them, here's what the potential is for the upside. Here's what happens if they prove X, Y, and Z. It could go badly to the downside.
Even when a case looks like an easy win in court, going to trial is risky.
If you get in front of a jury, it's Las Vegas. It's a crapshoot. You never know what can happen. You can have the best case in the world, and for some crazy reason, it can go down the toilet. On the other hand, if you take a settlement, it's guaranteed. You know what you're getting.
We explain the different options, and ultimately the client's the boss. You know, the client is the one that makes it. We work for the client. You know, we make our recommendations, but the client ultimately has a very active role in that decision.
The decision to go to trial is never an easy choice to make.
We give them all the possibilities we can. We give our recommendation, but ultimately the client makes the final decision on whether to go to trial. So what I tell clients, you take the last offer they've given you and you put it on the line and roll the dice. That's Las Vegas. You can hit big or you can lose it all. So you're always better off trying to settle.
The contingency fee rises if the client decides to take the case to trial.
You know, whenever you hire a contingent fee attorney, a contingent fee is, we don't get paid unless we win. But if we win, we get a percentage. We charge what all other attorneys, charge for personal injury, which is 1/3 of the gross. If the case has to go further, if we have to file and serve a lawsuit and go into formal litigation, it bumps up to 40%, also standard in California. But the costs also, it's fees plus costs.
Once we file the lawsuit, the fee increases to 40%, not necessarily just going to trial. I don't think when we make a decision about going to trial, we think about fees. At least it's not my motivation. I don't think about, we get a bigger percentage, or it's not what we're looking at. We're looking at what is in the best interest for the client.
And then Cusick will file the lawsuit.
So when we go into litigation, these cases can start to get expensive. But we will advance all the costs necessary to proceed on the case.
Normally, the settlement amount increases once the lawsuit has been filed, as the value of the case is reevaluated to cover the cost of the trial. Cusick advances all of the costs of going to court until the case is settled. If the client doesn't win the case, they are not responsible for those costs.
The value of a case is never static. It's always flowing one way or the other, because with every new piece of information that comes in, it either increases the value of the case or decreases the value of the case. You may take a deposition of the defendant and he's a horrible witness, or he may concede something regarding liability. They may take the deposition of the plaintiff, and well, if it's a person who's going to make a good appearance in front of the jury, who seems very credible, they tell a consistent story with their written discovery, they are in a worse position, we're in a better position. The value of the case goes up. We don't always necessarily just raise the ante just because now we filed suit. We may have a demand that we stick to. We just stick to their guns. Hey, the case has this value, we're not dropping below it. You guys need to get to it. And if you don't, we're going to go to trial and get that, and hopefully then some.
Typically, once we've served a lawsuit, we're in litigation, it may take a year before the case gets wrapped up, unless we can negotiate a settlement before that, or go to some form of mediation.
Filing the lawsuit is not the end of the negotiation for a fair settlement.
Of the 5 to 10% of our overall cases that we actually have to file a lawsuit on because we couldn't get the case settled at full value, of those cases, a small percentage of those will wind up all the way in front of a jury. Most cases will resolve either through continued negotiations, at a settlement conference, at mediation.
Mediation is a very good forum to try to resolve a case short of going to trial. It has to be agreed upon mutually by both sides. We often wait for the defense to try to proffer that idea, because if they're thinking that they want to go to mediation, then it's a better chance that we can settle the case. Whereas if we're trying to push for it, they might not be as inclined to want to settle.
For the most part, these other ways of resolving these cases present themselves. Client gives a good deposition, opportunity to resolve. Defendant gives a bad deposition, opportunity to resolve. Written discovery responses, maybe something pops up that makes the defendant even more of a bad guy than we thought. Another opportunity to resolve. So there's a lot of different jumping off points during the course of even a litigated case that present an opportunity to settle the case. And we're always pushing those opportunities for all they're worth. If we can get the case settled and not have to hire a bunch of experts, cost that comes out of the client's share, then we're going to push for that.
In the early phases of litigation, Cusick has the home field advantage.
Here at Cusick Law, we've been practicing for over 25 years and are really familiar with the judges in the Antelope Valley Courthouse, where most of the cases will be filed.
Everything up from the day we file up until that day we get sent out to trial, it's one of the judges here in the Antelope Valley.
And having that familiarity with the local judges really helps us efficiently move the cases forward and helps us advise our clients as to what may be coming.
A good lawyer is someone that knows the law. A great lawyer knows the judge. And out here in Antelope Valley, we know the judges, they know us. When we show up, they know what they're getting, and there's a mutual respect. And I think we do get some benefits. They know if we're telling them something, it's the truth, and we don't have to worry about we're playing any kind of games, because we don't do that. We don't play games in front of these judges because we're in our hometown, basically.
Cusick Law assigns one of its lawyers to handle each case through the litigation.
Typically, one lawyer handles the case from start to finish.
All of the lawyers at Cusick Law contribute to the individually designed strategy for each case.
We do roundtable and discuss. We have more senior litigators, than others naturally, but we all have different areas of expertise that we can draw on. We all put our heads together and we can come up with some solutions and ideas that maybe, wouldn't occur to me, and maybe somebody else here that's handled those types of situations before. and vice versa. So, we all work together, on these cases at discussing strategies, what experts to use, who's the better mediator, which arbitrator is best for this type of a case. We have definitely a wellspring of experience to draw from, and we do avail ourselves to that experience on just about every case.
Cusick Law targets the weaknesses of insurance companies.
The insurance companies, what they fear most is a fair fight. They only want to take a case to trial if the deck is clearly stacked in their favor. If it looks like they've got a fair fight on their hands, they're afraid of that because it could go either way, and they're probably going to want to negotiate towards a settlement or get it into mediation.
Cusick Law pushes for a pretrial settlement of a fair amount all the way up until just before the trial date.
If you go to trial, sometimes we take an extra lawyer. I have found in the personal injury arena that the defense typically only has one lawyer. Once in a while they bring two lawyers, never 3 or 4, unless it's just a huge case.
Cusick Law goes to trial at least once a month against a defendant who refuses to pay the fair amount.
All trials end up downtown Los Angeles. They're not tried here in the Antelope Valley. So we actually don't know who the actual trial judge will be until the day of trial.
If the defendant resists to the very end, Cusick lawyers know how to appeal to the better judgment of the jury to get a more than fair amount.
Court theatrics is a big part of the show if you get in front of a jury.
Cusick Law wins a majority of the cases it takes to trial.